Thank you very much, Sarah, and welcome to everyone who's joined us this afternoon. As we're adapting to the many changes that the pandemic has given rise to, I hope each of you is discovering something special about your unique qualities and abilities, and perhaps how resilient and adaptable we can be. So my topic, of course, has been presented as the virtual or the update on draft questioning protocols. I've been invited to speak to that topic. I have about 10 minutes. And what I thought I might do is just speak a moment about how we got here. I'm going to speak briefly as to the process we've undertaken. Then I will speak to some highlights about the protocol itself and where we might go from here. So just to carry on with what Sarah has indicated, as part of the ACLED COVID-19 emergency response team, Maya Tomljanovic, who is our VP, Donna Purcell, QC, who's been instrumental in all of these webinars, whose motto I have observed is, it's a brand new day, and who can I help today? And Terry Cooper, QC. So we're the COVID-19 response team. And ACLA was invited as part of the COVID response generally across the bar to participate as a member of the Civil Bar conference call that was held by Chief Justice Mary Morrow on April 9th. We were among many participants on the civil bar, and what quickly arose as a result of that call and that conversation with our Chief Justice and other members of the bench was a common concern about and an interest in developing a protocol around questioning by video conference. And what arose from that conference call was an invitation by the court to the bar to work together. And alas, from that invitation and from that basic interest that was expressed by so many, a small working group developed. Sam Leung took the lead in spearheading the initial draft. Sam is he's a senior legal counsel with Intact Insurance and the CBA South Insurance Chair. He took the lead, followed very quickly by Grant Watson, who has done tremendous amount of work on the protocol. Grant is with Watson Construction Law in Red Deer. Ola Malik is the CBA Alberta president this year, and he's with the City of Calgary Law Department, Law and Legislative Service Department, and he's part of our subgroup. Patrick Heinsohn, partner at Borden Ladner Gervais LLP, is part of our group. Donna Purcell, of course, QC and past president of ACLA, of Warren Sinclair LLP, and Julia Abanescu of Vista Law of Red Deer joined us with myself. And I say that and take a moment to say that because it's an indication of the vast array of experience and interest that has gone into the working group to prepare the first draft. So in terms of the process, major revisions, or many revisions, I should say, have gone back and forth amongst this small working group. And just as of yesterday, early in the morning, we agreed on a draft final product, if you will, that we felt was ready for dissemination to some of the organizations. And they included ACLA's board, the CBA, related executive section members would have received a copy, as I understand it. Mr. Peter Major of the Advocate Society, who's a partner at McLennan Ross, Ms. O'Para of Pro Bono Law Department, and the president of the Law Society all received a draft yesterday. Our intention was to ask for a quick turnaround because our goal is to put and present a final version, if you will, before the court this afternoon in advance of our next conference call that's being held with our Chief Justice and other members of the bench with the Civil Bar next week, May 7th. So we had a very quick turnaround. So for everyone who's expressed some interest and feedback, thank you. Now, what I want to do now is just in terms of the protocol itself, because it is not finalized, you'll note, of course, that we've not attached a version at this time. We certainly will. But what I would like to do now with that background and an understanding of where we came from and how we got here and who the players have been thus far and the extensive distribution that was made yesterday, I'd like to just speak briefly about, and in general terms, about the protocol itself. So we've entitled it Alberta Protocol for Remote Questioning. It is a 7-page document. It includes an appendix. And we certainly know that video conferencing remotely is not new to the bar. Certainly members of our practice, members of the bar have used the practice before if they've got counsel in other, if they're in one jurisdiction and maybe a witness is in another jurisdiction, etc. So we recognize the protocol or the practice isn't new. But what we're trying to do here with the protocol is we're trying to, number one, assist lawyers in their practice, standardize the process, provide some comfort to lawyers who, with experience, or those who are new to the process, that there's been some thought and some buy-in in terms of a proper protocol, and to allow parties to quickly agree to arrangements and procedures so that the procedure can move very quickly and so that we can provide access to justice for our clients, of course, because that is our number one priority. So in terms of the protocol, that was the overview, and that's the goal of the document. I should say that it is in no way intended to supersede any rule, right, obligation, term of evidence, etc., and that the parties always have an ability to agree to vary the terms of the protocol, but it is a standard one that we encourage people to at least consider and work with. So the protocol itself, as I say, covers 7 pages. It's not an extensive document. It is made up of a few topic items, if I may just speak to that. We've got a section on what's to happen prior to the questioning, so the selection of the technology platform. Of course, we're very concerned about security, and one of the we've identified some examples of possible platforms that counsel and parties may use, but ultimately security and the encryption of those platforms is number one, and counsel will have to satisfy themselves as to ensuring those measures have been taken into consideration. We have an obligation under the code to be technologically savvy enough to be able to manage some of these, so please satisfy yourselves as to those requirements. And of course, we have a duty to our clients to advise them of potential risks. So those are some of the comments that we speak to in terms of prior to the questioning itself and what items you might want to consider before you undergo this process. Scheduling will occur just as it normally would between the parties. We speak briefly about the equipment and the setting of the questioning, and the point to be taken away there is that with virtual questioning, we have to ensure to the best of our abilities and to encourage the participants to think along those same lines, that wherever the questioning is going to occur should replicate as close as possible to an actual questioning, so that the privacy and that the surroundings reflect a quiet, private setting, and that those considerations are made in advance. With respect to records, we've spent a great deal of time determining a process regarding records. We've settled on a secure online records depository as a first starting point, with the ability of parties to determine what documents in advance should be shared. There is an alternative choice there because there are some platforms, perhaps, or parties that may determine for themselves and in their action that a very secure online depository, while required, perhaps there can be a version of that that's appropriate for the circumstance and as agreed to by the parties. We encourage all of the parties to do a test run, just like we did this morning here in advance of this webinar, just because these things are new. And as we get more proficient, maybe that may not be necessary, but a test run will be necessary in our view to ensure that the process runs as smoothly as possible, because it is a formal proceeding. With respect to the process itself, the questioning, we've gone to some extent to set out the general rules that's expected of each participant. The expectation is that the court reporter will host the questioning, so that there is some control by the court reporter, as she normally would or he or she would in a questioning. And there are steps that have to be taken by the court reporter in advance to take that control. And of course, to ensure, because it's a virtual process, to ensure that only those participants who are giving evidence and hearing evidence and able to hear evidence are the participants intended to be able to do that. We've set out a specific paragraph in the protocol that in advance of the questioning beginning, the parties have to agree on the record to adopt the protocol, or if there's been a change to the protocol, to expressly state those changes so that it's clear and it's dealt with in advance of the questioning starting. The court reporter will then administer the oath or affirmation as she normally would. And in that process, we've accounted for a certain number of questions which are attached at Appendix A to be put to the witness. And part of that is an agreement that nobody's going to record or rebroadcast that, and I'll speak to that in a moment. The rules of evidence and admissibility, of course, continue to apply, and it's expected that those rules of evidence and rules of court will substantially be followed. At the end of the questioning and before it's concluded, the court reporter will, as part of her certificate, make it very clear that the questioning has occurred by virtue of this protocol or a protocol that's been agreed to, and that it's noted in the certificate so that that is consistent with our trying to take all measures practical to ensure that we are following the proper procedures, and that where we have used the questioning in a virtual sense, that it's recorded as such. Appendix A is the 7th of 7 pages to the protocol, and it's at that place where the witness is asked to certify, confirm, and undertake a series of 9 points. And I'll just read the first example as an example. It says, you have agreed to be questioned by way of video conference, and the evidence that you give in these proceedings may be used by any party in accordance with the Alberta Rules of Court and in accordance with the Rules of Evidence. We're going to be tweaking that piece actually as a result of some feedback we received. So and then it goes through a specific undertaking to behave, to conduct, to agree, to accept that the normal practice in specific itemized points, as I've indicated here, are actually going to be agreed to. As it relates to the recording or rebroadcasting of these proceedings, we have specifically asked that all witnesses confirm that they will not undertake to do that, and that they understand that if they breach that promise and undertaking, that they may be subject to legal sanction, including proceedings of civil contempt of court. We took that piece directly from the Queen's Bench undertaking of non-lawyer, and the purpose of that is to underscore the importance of this proceeding. It is a formal one, and if someone were to not understand that, the onus, and understand the severity of that undertaking, they would at least be able to understand that legal action can be taken. Because if someone didn't understand and then went on to perhaps record or rebroadcast, damage could potentially be done. And so we're trying to enforce a very strong message of certain appropriate behavior and conduct. So as I say, there are 9 questions and points for verification, certification, and confirmation by the witness. And that would then form the completion of the protocol. In terms of where we go from here, as I say, I'm just repeating this point, we are going to be putting and presenting the protocol before the court. We're very interested if they have any feedback, and we'll of course be open to their feedback and incorporating their comments and suggestions. That's going to possibly be a point of discussion next Thursday. We don't know. It'll be our next civil bar call, as they say, is on May 7th. And thereafter, then we hope to be in a position to distribute the protocol very widely. So what I've reviewed with you then today is I've given you a little bit of background as to how we arrived, how the protocol sort of was brought into being, if you will, or carried forward. A little bit of the process that we've undertaken to be sure that we've had some significant collaboration and feedback. I've given you a bit of an overview of the protocols, and then as to next steps. So therein is my presentation, and if there are any questions, I'll do my best to answer them. Thank you.
Thanks very much, Angela. We do have a few questions for you. The first question that came in is from Basil Bensal. He says, when sending a notice of appointment for questioning, what is the recommended protocol to enter for the location of the questioning on the document?
Okay, so perhaps what we might do, those are very particular technical issues, and that's the sort of thing that we could envision that the parties would be discussing in advance. But certainly where the location is going to occur should be stated in the protocol. And in terms of, again, that's a very important piece, but something that I think can be worked on with between the parties. But again, if there's maybe, so that's one thing, maybe if there's going to be lots of these questions, I could also take them back to the group and answer them. But does that answer my friend's question?
I think that does. There are just two other quick questions. One's from Rob O'Neill. He just says, how do you ensure that no one else is in the room when the person is being questioned and the camera is sort of out of view?
Well, that's exactly excellent point, Rob. And I'll just speak to the question in the appendix that we've currently drafted. I'll just find that question. Just bear with me. So to that point, it is very much an undertaking. And so what we do here is where we've said, I guess in general terms, you'll have reviewed the protocol for questioning, which of course is precedes by 6 pages, the appendix, and you agree to comply with all parts of that protocol as modified on the record if applicable. And so in the body of the protocol, as part of the duty of each participant, there is a section under general rules of virtual meeting which deal with that in some detail. So for example, it says, with the exception of the court reporter, you're not going to record the virtual meeting. In the event of an interruption, you'll communicate with the court reporter. You'll take steps that anyone else other than the participants in the virtual meeting from hearing or seeing the contents of the meeting other than the parties are prevented from participating. So that sort of thing. So Rob, we have addressed our mind to that, and we hope that with these questions and these the expectation of conduct and the undertaking at the end, at the forefront, but attached as Appendix A to the end, will address those concerns.
Thank you, Angela. And just a few quick questions for you as well. Steve Major has a question about getting a copy of the draft protocol.
Okay, so Mr. Major, we are now at a point in the process where we're going to be presenting it to the court, and if they have feedback, then we will be incorporating that. Otherwise, we expect to be able to provide a copy of the protocol after next week's conference call, which is May 7th.
Okay, wonderful. And then has the group turned their mind at all to the issue of conduct money and how that might be done remotely through e-transfer or some other means?
Conduct money isn't a matter that's come up. Presumably, if everyone is in the comfort of their home, that might not be an issue. But I would imagine, although I'll bring that back specifically, and perhaps we should add that as a point if it's being raised here, if there is any expense on the part of a witness, I can't imagine why it would be any different. But thank you to that caller. I'll make a point of that to see if we can at least address it so it's not left unanswered.
We've got a final question from Sonia, who's asking if there's going to be a sample or precedent document for the notice of appointment for questioning. So as part of the protocol, if there will be any additional templates or anything created that people can use.
So this protocol should be the groundwork that's available to, obviously should enable all participants to attach this protocol then, or to agree to it and to enter it as part of the documents. As to whether there's a template attachment to it, we haven't prepared one, and certainly if that's that we can certainly consider that. I should also say that what we've observed is that there has been a lot of interest in this document, and even with the feedback, lots of great interest. So we expect that this is going to be a living document, and as the months go on, we may need to revisit it from time to time. So please, keep your comments coming, and we'll address them as appropriately. So thank you very much.
Excellent. Thank you very much, Angela.